The President and the Prime Minister, also known as the two principals. They are the pillars of the Grand Coalition government that came into existence on 28 February 2008 after the signing of the National Accord. According to the Constitution, the National Accord forms a key part of the transitional clauses that touch on, among other things, the appointment of a new Chief Justice and a new Attorney General. The key word under scrutiny now is consultation, defined by the Oxford Online Dictionary as the action or process of formally consulting or discussing. A small word, but one that is hugely significant nonetheless.
If they want consultation, the first practical consequence of what you expect is what you started seeing last night. You'll expect political noise, because you'll expect complaints from the other side, and that is what consultations were.
Government spokesman Dr. Alfred Mutua says that the said consultations on the appointments actually took place and had been going on for quite some time since Christmas.
It is therefore insincere and misleading for any person to say that consultations had not been made before the appointment of the new judicial officials.
But although he acknowledges that consultations did take place, he warns that it would be wrong to expect the same to go on smoothly all the way.
Consultations do not mean 100% agreement or 100% consensus. Otherwise, the country would never move forward.
The Constitution is clear that the appointments should only take place after the President consults the Prime Minister. Although both the government spokesman and representatives of the ODM side concede that talks on the matter had been going on, it appears that new differences arose yesterday. According to Raila, he had asked that the decision on the appointments be delayed until after his Addis Ababa trip. But Dr. Mutua disagrees.
Kufikia Alhamisi asubuhi, hapo jana asubuhi, viongozi hao wetu wawili walikuwa wameshakubaliana tayari kuhusu majina matatu.
It is clear that differences over the issue of whether the ICC cases on Kenya should be deferred may be part of the bigger picture in the appointment saga. Vice President Kalonzo Musyoka has been on a diplomatic charm offensive, seeking the support of African states and having the ICC cases deferred. Musyoka's statement that he was acting on the instructions of President Kibaki and the fact that Raila insisted that there was no agreement that Kenya seeks a deferral of the ICC cases split the government on the issue. If President Kibaki needed to have the names before his trip to the AU summit, it means he's out to convince the heads of state there that Kenya has reformed its judiciary. Raila, on the other hand, was not in support of the calls for deferral and has instead opted to support a referral of the cases to the ICC. With Kibaki and Raila not agreeing on a stand to present together to the ICC, the differences were bound in one way or another to affect the key judicial appointments. But according to law lecturer Collins Odote, the matter has not been cast in stone.
Under the new constitution, all constitutional appointments, the president only has the powers to nominate, and until and unless parliament debates and approves, they do not become formally appointed persons to take up that office.
The only way out of what the premiers call the constitutional crisis, it appears, would be for the two principals to perhaps yet again seek refuge in another small but equally important one, consensus, and help avoid further polarization within government. Abdi Osman, Citizen Weekend.